Hello friends, in this video lecture we will be discussing maintenance right of a Hindu wife. So a Hindu wife can claim maintenance under different laws and different acts. So we will be discussing all such laws and acts, under how many acts or laws can a Hindu wife can get maintenance. Okay. So the maintenance right she can claim maintenance under Hindu Marriage Act also. Okay. One can claim maintenance under CRPC also, and CRPC is a secular law. So even a Hindu wife, a Muslim wife, a Christian wife, anyone can claim maintenance under the CRPC. Then a Hindu wife can claim maintenance under HAMA, Hindu Adoption and Maintenance Act, and she can also claim maintenance under the Domestic Violence Act. Okay, this is also a secular act, secular law. In this also, wife of any religion can claim. Okay. Now, if we see that what all sections are there, so it is section 24 and 25 of Hindu Marriage Act, in which a Hindu wife can claim. Now, this section, it is either husband or wife. This is the only section, these two, that either husband or wife can claim maintenance. Either husband or wife, okay, or wife can claim maintenance. Then there is CRPC section 125, in which a legally wedded wife can claim maintenance. Then there is HAMA, in which a Hindu wife can claim maintenance. And then there is Domestic Violence Act, in which a Hindu wife can also claim maintenance. Okay, so it is only Hindu Marriage Act in which either husband or wife can claim maintenance. So we will be discussing each and every section one by one. So firstly, we will see section 24. So section 24 is also called मेंटेनेंस पेंडेंट लाइट एंड एक्सपेंस ऑफ द प्रोसीडिंग. सो मेंटेनेंस पेंडेंट लाइट का मतलब क्या, दैट अ पर्सन विल गेट मेंटेनेंस टिल द टाइम कोर्ट केस इज पेंडिंग, और टिल द टाइम कोर्ट case for divorce or for judicial separation is pending. And one can also recover the expense of the litigation, the expense of the proceeding. तो मान लीजिए अगर डाइवोर्स का केस चल रहा है, so till that time, जब तक वो केस चल रहा है, one can get the maintenance. Okay. So this is what section 24 is all about. So maintenance under section 24 is temporary or interim. So one will get temporary or interim order, okay, of maintenance. Okay. So this is what maintenance pendent light and expenses of proceeding is all about. So if we see, one can claim maintenance. Maintenance can be made for personal maintenance, can be claimed. जब तक कोर्ट केस चल रहा है, वाइफ कैन क्लेम फॉर पर्सनल मेंटेनेंस एंड ऑल्सो फॉर द एक्सपेंस ऑफ द प्रोसीडिंग, एक्सपेंस ऑफ प्रोसीडिंग, कोर्ट प्रोसीडिंग्स. ठीक है, तो एक्स कोर्ट के खर्चे के लिए भी और अपने खर्चे के लिए भी शी कैन क्लेम मेंटेनेंस. इसमें हस्बैंड कैन ऑल्सो क्लेम मेंटेनेंस. ओके, but they have to show that they does not have any independent source of income. कोई भी independent source of income नहीं है. ठीक है, source of income नहीं है. And while deciding the quantum of the maintenance, court will keep in mind the income level of the respondent and the petitioner. वाइफ और हस्बैंड दोनों का इनकम लेवल को देखा जाएगा. ये भी देखा जाएगा कि कंडक्ट ऑफ वाइफ और हस्बैंड क्या था, किसकी गलती की वजह से डिवोर्स मिल रहा है, अगर वो प्रूफ हो सकता है तो हाउ what was the conduct, and also how many members has to be maintained. अगर कोई बच्चा भी है, so genuinely the maintenance amount will be more. Okay. So now if we read the section 24, it is about any proceeding, whether it is proceeding of divorce, judicial separation, or any proceeding. Therefore, the word any is given. The one can claim maintenance. Okay. Under this act, it appears that either husband or wife can claim maintenance if they have no independent income sufficient for his or her support and necessary expense of the court proceeding. ठीक है, then on the application of husband or wife, the court may order respondent to pay such amount, keeping in mind the petitioner's own income and the income of the respondent. Okay, and whatever situation or conditions which court thinks reasonable. So ये सब देखते हुए the court will order the quantum of the maintenance. Okay, so this was all about section 24, which is called maintenance pendent light and expense of proceeding. Now we इसमें एक पॉइंट और है कि जब भी अगर मान लीजिए वाइफ कोर्ट में डिवोर्स का प्रोसीडिंग चल रहा है और वाइफ ने मेंटेनेंस के लिए एप्लीकेशन डाली, देन दैट एप्लीकेशन हैज टू बी डिस्पोज्ड ऑफ. कोर्ट को उस एप्लीकेशन को जल्दी से डिसाइड करते हुए 60 डेज के अंदर, जब हस्बैंड को मान लीजिए नोटिस मिल गई कि ऐसा एप्लीकेशन फाइल हुआ, उस डेट से 60 डेज के अंदर ही हैज टू द कोर्ट हैज टू गिव द मेंटेनेंस और डिस्पोज द मेंटेनेंस एप्लीकेशन। ठीक है, तो मतलब 60 डेज के अंदर एक टाइम लिमिट डाल दिया, मेंटेनेंस मिल जानी चाहिए बिकॉज इट इज समथिंग ऑफ अर्जेंट नीड। सो 60 डेज फ्रॉम द डेट ऑफ सर्विस ऑफ नोटिस, जो एप्लीकेशन फाइल किया कोर्ट में, तो कोर्ट उसका नोटिस हस्बैंड को भेजेगी ना, तो उस डेट जब हस्बैंड को मिल गया नोटिस, उससे 60 डेज के अंदर ही मेंटेनेंस का अमाउंट मिल जाना चाहिए। Now we have section 25. Now section 25 deals with permanent alimony and maintenance. Okay, now this deals with permanent alimony and maintenance. अब इसमें क्या है ना, मान लीजिए डाइवोर्स अब पास हो गया, तो डाइवोर्स पास होने के बाद भी वाइफ कैन क्लेम मेंटेनेंस। इसमें भी husband can also claim maintenance if wife is earning a lot. Okay, it may happen that husband is unemployed and wife is the only bread earner of the house. Okay, so it is only section 24 and 25 in which either wife or husband can claim maintenance, or else in every other section it is only wife who can claim maintenance. Okay, so if we see section 25, first thing is that either husband or wife can claim maintenance. This maintenance will be a permanent alimony. It can be given on one lump sum amount, or it can also be given on some installment basis. Okay, now it can, the maintenance amount can go till 1/5, अगर मान लीजिए वाइफ मेंटेनेंस मांग रही है, till 1/5 of the husband's income में, मतलब 20% of the husband's income can be given to the wife. Okay, if she is claiming the maintenance, 20%, it can go till 20%. Okay, also we have to see that even if अगर divorce, even if wife has done some matrimonial offense और divorce wife की गलती की वजह से मिल रहा है, then also she does not loses her maintenance right. She will still get maintenance. Okay, ये हो सकता है कि अगर उसकी गलती की वजह से ही डिवोर्स हो रहा है एंड इट कैन बी प्रूव्ड, देन द क्वांटम ऑफ मेंटेनेंस कैन बी रिड्यूस्ड। अगर इवन इफ मान लीजिए वाइफ हैज डन सम एडल्टरी, उसने आउटसाइड द वेडलॉक उसने कुछ एडल्टरस एक्ट किया एंड डिवोर्स इज पास्ड ऑन द ग्राउंड ऑफ एडल्टरी, देन ऑल्सो वाइफ कैन क्लेम मेंटेनेंस। हाँ, अगर मान लीजिए डिवोर्स का केस चल रहा है, लेट से डिवोर्स बाय म्यूचुअल कॉन्सेंट, और भी ऐसे इन जनरल अगर डिवोर्स का केस चल रहा है, एंड आफ्टर द केस द वाइफ इज हैविंग some sexual relationship with someone else, then the court will only give bare minimum maintenance because she is all obviously she is already having sexual intercourse with somebody else to whom she has not married. Okay, but if she is not at all earning, and then if she is found to be unchaste means to have sexual relation with someone else other than being getting married, then she will get only a bare minimum. अगर वो एकदम ही नहीं पैसा कमा रही है, then she has the right to get bare minimum amount of maintenance. But अगर she is earning and she is indulging into sexual activity with someone else, then the court will not give maintenance. Okay, हाँ, ये बात अलग होती है कि अगर मान लीजिए डाइवोर्स ही एडल्टरी के ग्राउंड में मिल रहा है बिकॉज एट दैट टाइम दे वर मैरिड व्हेन दिस एडल्टरस थिंग हैपेंड, तो अगर डाइवोर्स के बाद भी आपको मेंटेनेंस मिलेगा। बट अब अगर मेंटेनेंस का एप्लीकेशन चल ही रहा है और डाइवोर्स की प्रोसीडिंग चल रही है, और उसके बाद इफ समबडी इंडल्जेस इनटू और not remains to be chaste or she is unchaste, then she will get a bare minimum if she has no source of income. Okay, so now in this section if we see section 25, it is at the time of passing any decree, so it means decree of divorce, judicial separation, or anything on the either the wife or the husband, either husband or the wife as the case may be. Okay, यहाँ husband और wife दोनों ही claim कर सकते हैं maintenance. ठीक है, यहाँ क्योंकि ये परमानेंट एलिमनी है, देन इट कैन बी अ ग्रॉस सम, अ लंप सम, और इट कैन बी अ मंथली और पीरियोडिकली सम टिल द लाइफ ऑफ द क्लेमेंट। आपको मेंटेनेंस देना पड़ेगा अगर वो मंथली इंस्टॉलमेंट है या पीरियोडिक इंस्टॉलमेंट है। ओके, हाँ, कोर्ट ये चीज देखेगी कि रिस्पोंडेंट का इनकम क्या है, उसकी क्या प्रॉपर्टी है, उसकी क्या स्टैंडर्ड ऑफ लिविंग है, वाइफ की इनकम क्या है, उसकी क्या प्रॉपर्टी है, उसकी क्या स्टैंडर्ड ऑफ लिविंग है। देखिए सब यहाँ मेंशन भी है, हैविंग रिगार्ड टू रिस्पोंडेंट्स ओन इनकम एंड अदर प्रॉपर्टीज, ओके, इफ एनी, the income of the wife also, the income and other property of the applicant also, अगर applicant wife है तो उसका भी, the conduct of the parties and other circumstances of the case also, इन सबको ध्यान देते हुए the court will pass the maintenance amount. So this is what section 25 subclause 1 states. अब इसमें जो है section 25 subclause 2 is something really very important. Okay, because subclause 2 क्यों important है, because the court has power, if there is a change of circumstances, if there is a change in circumstances, the court has power to vary, modify, reduce or rescind the maintenance amount. ठीक है, तो वो मेंटेनेंस अमाउंट को बढ़ा सकती है, घटा सकती है, खत्म भी कर सकती है अगर कोर्ट को सही लगे तो. सो इट कैन, दिस सेक्शन, section 25 sub clause 2 is used a lot when wife is claiming maintenance in some other act also. ठीक है, मान लीजिए उसको सेक्शन 25 में पहले मेंटेनेंस मिल गया, उसके बाद वो चली गई सेक्शन 125 सीआरपीसी में भी पाने, ठीक है, वहां से भी अब उसको वहां पे भी जो ऑर्डर है वो पास हो गया, उसको वहां से भी अब मेंटेनेंस मिल रहा है, हस्बैंड दोनों जगह मेंटेनेंस दे रहा है, तो हस्बैंड कैन put an application that there is a change in circumstances, she is also getting maintenance under section 125, so please reduce this amount. अब सीआरपी सेक्शन 125 सीआरपीसी में ऐसा कोई प्रोविजन नहीं है मेंटेनेंस अमाउंट को चेंज करने का, बट इन दिस सेक्शन the husband can go and at least reduce the maintenance amount in one of the act. Okay, so this is also there. And also the court may rescind, अब clause 3 क्या कहता है, the court may rescind the maintenance if one of the party remarries. अब मान लीजिए वाइफ ने दोबारा शादी कर ली, then the court can rescind the maintenance, or if she or if the husband is able to prove that the wife remains unchaste, sorry, the wife remains, or the wife is not chaste, the wife is unchaste, if he is able to prove, then also the court can rescind the maintenance under section 25 subclause 3. ठीक है, so if the court is satisfied that the parties in whose favor the order has been made has remarried, या तो उसने दोबारा शादी कर ली, or if such party is the wife, then she has not remained chaste, वो chaste अब नहीं है, और अगर वो पार्टी हस्बैंड है, then he had sexual intercourse with any woman outside the wedlock, तो हस्बैंड को भी नहीं मिलेगा, और अगर वाइफ इज हैविंग इज नॉट रिमेन चेस्ट, तो वाइफ को भी नहीं मिलेगा. ठीक है, एज पर सेक्शन 25 सब क्लॉज 3. ओके, because it's like you are getting a maintenance also and you are having an affair with somebody else also, so both things won't go together. ठीक है, तो ये section 25 सब क्लॉज 3 में given है. So now we have done the maintenance under section 24 and 25 of हिंदू मैरिज एक्ट. तो हिंदू मैरिज एक्ट के हिसाब से मेंटेनेंस इज ओवर. इसमें ईदर हस्बैंड और वाइफ कैन क्लेम मेंटेनेंस. सेक्शन 24 में इट कैन बी क्लेम्ड ओनली टिल द पीरियड ऑफ लिटिगेशन, एंड 25 it is about permanent alimony. Okay, now we will see the next act. Okay, so next is section 18 of Hindu Adoption and Maintenance Act. This is section 18 we will see. Okay, we have already done with Hindu Marriage Act, section 24 and 25. Okay, now we will be seeing section 18 of Hindu Adoption and Maintenance Act. Okay, so अब section 18 of Hindu Adoption and Maintenance Act, अब इस section में it is the only Hindu wife who can get maintenance. इसमें husband को maintenance नहीं मिलता. ठीक है, so it is only the wife, the Hindu wife, who can get maintenance under section 18 of the Hindu Adoption and Maintenance Act. ये एक different act है. ठीक है, why only Hindu wife is given? Because it is the moral duty of the husband to maintain his wife for lifelong, okay, for the lifetime. So a Hindu wife is entitled to be maintained by her husband during her lifetime. अब इसमें एक और कंडीशन है दैट द वाइफ मस्ट लिव विद द हस्बैंड। मान लीजिए कोर्ट केस चल रहा है, बट टू क्लेम मेंटेनेंस अंडर सेक्शन 18 of HAMA, Hindu Adoption and Maintenance Act, the wife should live with the husband. अब अगर वाइफ हस्बैंड के साथ नहीं रह रही है, देन शी हैज टू शो दैट देयर इज सम जेन्युइन रीजन, द रीजन लाइक द हस्बैंड इज बीटिंग हर, द हस्बैंड इज डूइंग cruelty to her, the husband is suffering from leprosy, the husband has not remained Hindu, the husband has brought some other lady into the house with whom he is having sexual relation, or husband has married someone else, or husband is willfully neglecting her. So इस सारे cases में the wife can live without husband, live in a separate residence, and can claim maintenance also, and she can also claim the cost for living into a separate residence, उसका rent भी she can claim. Okay. अब इस section 18 में if Hindu wife will not be entitled to a separate residence and maintenance if she is found to be unchaste. If husband can prove that she has remained unchaste, okay, or she has done sexual activity with someone else, then the Hindu wife will not be able to get maintenance. Or if the husband proves that she has converted the religion, then also, because section 18 is applicable only for Hindu wife. Okay, so this is what all about section 18 of Hindu Marriage Act. So that Hindu wife shall be entitled to be maintained by her husband during her lifetime. The first clause itself says a Hindu wife shall be entitled to live separately from her husband without forfeiting, without giving up her claim to maintenance. अगर husband is guilty of desertion, मतलब उसको छोड़, मतलब उसको पे ध्यान नहीं दे रहा, willful neglect है, ठीक है, if he has treated her with some cruelty like domestic violence or some mental torture, if leprosy is there, if he has some other wife, if he has kept some concubine, some any other woman for sexual activity, if the husband has changed his religion, okay, then the Hindu wife shall be entitled to a separate residence. अब clause 3 क्या कह रहा है? Hindu wife shall not be given separate residence and maintenance if Hindu wife is unchaste. Okay, if she is unchaste, if she's having some sexual relationship with someone else, then she won't get maintenance under section 18 of HAMA or separate residence under section 18 of HAMA. But and also if she ceases to be Hindu, agar wo Hindu nahi hai, then also she won't get such maintenance. Okay, so this is all about section 18 of Hindu Marriage Act. Okay, now we will be looking at different act, which is CRPC, section 125 of CRPC. So we have done with Hindu Marriage Act 24 and 25, we have done with Hindu Adoption and Maintenance Act, which is section 18. Now we will be seeing section 125 of CRPC. Okay, so section 125 of CRPC, if we see, this is a secular act in which a Hindu wife or a Muslim wife both can get, but the the woman should be a lawfully wedded woman. Lawfully wedded woman, वो उसकी wife होनी चाहिए, ठीक है. So, and also if the wife, the legally wedded wife, is also having some illegitimate children, then such illegitimate children can also claim maintenance. Okay, so illegitimate children from second wife are also entitled to such maintenance. Okay, मान लीजिए अगर उसने second wife रखी, उसकी wife पहले थी और ये बात wife को पता थी, so the second marriage is not legally valid, but the children of such marriage can also claim maintenance under section 125 of CRPC. तो CRPC के लिए वाइफ का लॉफुली वेडेड होना जरूरी है. बट अगर मान लीजिए हस्बैंड ने पहली शादी कर रखी हो, वो दूसरी शादी करता है, तो हिंदू मैरिज के हिसाब से द सेकेंड मैरिज इज नॉट लीगली वेडेड because the person was having a wife at the time of marriage. Okay, And if the wife was knowing this fact and then also she entered into marriage and she also had a children, then such illegitimate children will also get maintenance under section 125, even though the wife may not get the maintenance. देयर कैन बी एक्सेप्शन ऑल्सो. मान लीजिए हस्बैंड की पहले शादी हो रखी है, लेकिन हस्बैंड ने वाइफ को जब सेकंड वाइफ को बताया ही नहीं था फर्स्ट मैरिज के लिए, ओके, देन a certain exception can be made and even wife can claim maintenance under section 125, because the court cannot allow the husband to take advantage of his own wrong. उसने तो वाइफ को बताया नहीं the second wife को कि उसकी पहली शादी हो चुकी है. Okay, so certain exception can be made but it will not be in all the cases. Okay, so this was all about the section 125 of the CRPC. इसके अंदर भी one can claim maintenance. Okay, then we have the last section, which is section 20 of the Domestic Violence Act. So CRPC का section 125 is also over. Then we have section 20 of the Domestic Violence Act. अब इसमें देखिए section 24 and 25 is similar. Section 24 and 25 is similar, and section 18 and 125 of CRPC is also similar, क्योंकि इसमें husband maintenance claim नहीं कर सकता, but 24 and 25 में husband can also claim maintenance. So if we see that 18 and 25 में 125 में only the wife can claim maintenance, but 24 and 25 में it is the husband who can also claim maintenance. Okay, 18 or 25 में wife can claim maintenance and she can also live separately from the husband, but 24 and 25 में either spouse can claim maintenance only after divorce or judicial separation. ठीक है, ये सिर्फ 25 में, 24 में तो during the course proceeding also one can take. Okay, so the difference between 25 and section 25 of Hindu Marriage Act and section 18 and 125 of CRPC and section 18 of HAMA is that the wife can claim maintenance and live separately from the husband even during the marriage under these two provisions. But in section 125, she cannot live separately during the marriage, okay, because this maintenance will be only given after divorce. It is section 24 in which during the court proceeding also one can claim maintenance. Okay, so this was all about these three sections. Now we will be seeing section 20 of Domestic Violence Act. तो देखिए Domestic Violence Act also becomes important. This will be the last section. अब ये क्यों important हो जाता है? Because section 20 is important because it also covers the palimony. Palimony का concept क्या है? मान लीजिए अगर कोई couple है who is those who are living in a living relationship, उन्होंने शादी नहीं करी है बट वो लिविंग रिलेशनशिप में रह रहे हैं, तब ऐसे लिविंग रिलेशनशिप में जो फीमेल पार्टनर है कैन शी क्लेम मेंटेनेंस. ठीक है, तो इसके ऊपर सेक्शन 20 becomes important. So the wife can, if the female is the wife, then she can claim maintenance under Domestic Violence Act also, and this maintenance will be secular. Anyone can claim, but there has to be a complaint case of domestic violence. If she is subjected to some domestic violence, then only she can claim maintenance. Okay, but also this section 20 of Domestic Violence Act also includes the word palimony. Even if they are not legally wedded and they are living or as husband and wife, they are living in a living relationship, then also the female partner can claim maintenance, because see, as such, living relationship is not recognized by the law. Okay, living the status of living relationship is not recognized by law. Okay, so since it is not recognized by law, therefore the rights for maintenance becomes difficult. There is no such legislation or law which recognizes a living relationship. Thus the rights and obligation of the parties in such relationship becomes difficult, and also the status of children born out of such relationship also becomes difficult. So Domestic Violence Act 2005, Domestic Violence Act 2005 provides for protection, maintenance and rights of living partners also. So the palimony, a form of alimony paid to a former partner in a non-marital relationship or a female partner in a living relationship are included under Domestic Violence Act. ठीक है, तो डोमेस्टिक वायलेंस एक्ट में ये इंक्लूडेड है अ फीमेल पार्टनर। क्यों? क्योंकि इसमें जो है ना, जो जैसे कि 24, 25, 125 में द वर्ड यूज्ड इज लीगली वेडेड और द वाइफ, द वर्ड वाइफ इज यूज्ड और द वर्ड लीगली वेडेड इज यूज्ड। ओके, बट इन डोमेस्टिक वायलेंस एक्ट इट इज used that if male and female are into a relationship, if husband and wife into a relationship, so the word relationship is used. So the court has broadened this term. Yes, the living relationship is not recognized by any law, but as far as maintenance right is concerned, since the word relationship is used under Domestic Violence Act, therefore the court can grant maintenance right to a female partner in a living relationship also if she is subjected to some domestic violence. Okay, if you see section 2F, section 2F of Domestic Violence Act, then that uses the word relationship. Therefore a female partner can also get the protection. Okay, okay, so this was all regarding the living relationship. Now why the palimony was not given? Because in living relationship, since it was not recognized by the law, so giving any amount can promote or can give legal sanctity to bigamy. ठीक है, मान लीजिए किसी की शादी हो चुकी है बट वो लिविंग में रह रहा है और किसी के साथ, सो इट विल प्रमोट, एंड इफ सच वाइफ कैन आल्सो क्लेम despite she is knowing that the husband is legally wedded, she then it will be like giving legal sanctity to bigamy. But in Domestic Violence Act, even the live-in female partner can claim maintenance. Okay, so this was all about the maintenance right, which includes the Hindu Marriage Act, which includes the CRPC, which includes the section 18 of HAMA, and includes section 20 of Domestic Violence Act. So thank you all. I hope that I have covered the maintenance right relating to the topics well. Thank you all. Okay.